Welcome back. The ballistics experts in the Senzo Meyiwa murder trial are not too far off with their opinions on the bullet found in the house, matching the gun recovered from accused number 3. For some legal analysis on this, we're joined by legal expert or legal analyst, Kabelo Siabi. Kabelo, thank you so much for your time. It seems the two experts are going to the same direction, but the defense expert says, I'm falling short to meeting the threshold to say that this is definitely a match. What is your view on what the two experts are saying about this?
Thank you, Linda. The expert, one must remember, experts give opinion evidence. They tell the court that when they examined the item and they applied their knowledge and experience, these are their findings. Now, what is happening in the trial at present is that the expert of the state, Lieutenant Colonel Chris Mangena, has told the court as to how he examined the bullet that was found at the scene and how he had compared that bullet to other bullets which he personally fired so that he could do a comparison. And he has taken the court through the process and to tell the court how he arrived at the conclusion that there is a match. The defense, however, have been putting suggestions that their expert examined the bullet found at the scene, and their expert also compared that bullet to bullets that were fired in the firearm which was recovered from the accused. Now, their expert is saying he cannot find sufficient markings on the bullet to come to the conclusion, the same conclusion as Lieutenant Colonel Mangena. But the striking part is that he says that the class characteristics of the two bullets match. When it comes to the individual characteristics, he says he can see some, but they are not sufficient for him to come to the conclusion that there is a match. So, in essence, the defense expert has not disputed the findings that were made by Lieutenant Colonel Mangena. And the cross-examination that has been unfolding, unfortunately, has not come to the point where the findings of Lieutenant Colonel Mangena are being disputed as not being correct. And that is what probably the court is expecting to hear, that the findings which Colonel Mangena reached, those findings are incorrect. But this far, there's been a lot of questions put, but we have not heard the suggestion from the defense that that which Colonel Mangena says was his conclusion was wrong and why it was wrong.
And I find it interesting, as you put it, Kabelo, that they're not disputing this particular evidence. In fact, it seems as though what they're relying on, based on their expert's opinion, is that this could be an issue of subjectivity. I remember the court asking, what is the subjectivity based on? And Mangena saying, well, it depends on one's experience. We don't know what the defense's expert's experience is, but we certainly do know that Mangena has been in the field, in the SAPS at least for 30 years and in ballistics for 29 years. Do you think it will boil down to who the court believes?
That's what I was trying to sketch, Linda. The problem that the proceedings have opened this week is that the state expert, Lieutenant Colonel Mangena, says these are my findings, and he explains how he got to those findings. Now, the defense is not, and this is what they should have been or were expected to do, would be to come to court and say, your findings with the assistance of our own expert are incorrect. What you say you found and the conclusion you reached is incorrect because of the following. But that is not what is happening with the cross-examination. There is nothing that has been said directly to Colonel Mangena to say that the evidence that you've given about what you say are your observations and what you say are your findings is incorrect. And it is incorrect based on the following.
And now that they're not saying that, is there a point in then even going and as far as saying you did not sufficiently make a link between this bullet and this firearm? The issue of now questioning that firearm and whether this firearm is the same one that Rudolph's used in his investigation. Is there a point in even questioning that when seemingly the expert is going to the same direction but seems to say, we've fallen short of what you say is sufficient?
That is the point. And that is what I'm trying to explain. From their cross-examination, it would seem that their expert, when their expert come to testify, the defense expert that is, he is going to say, I agree with Mangena up to this point, but because I could not find certain other issues, I do not agree with him 100%, but he is going to largely agree with what Colonel Mangena said. And that is what is the problem that has unfolded this week. The court is now not being told that Mangena is wrong.
And if he does that, and if he agrees with him to a certain point, it would be a blow for the defense.
That's exactly the point. If he has already, or it has been put on record that the defense expert agrees that the class characteristics are similar, meaning that the firearm that fired the bullet at the scene and the firearm which is the exhibit falls within that broad classic. In the broad classic definition, it is the same firearm. Now, what is now outstanding is that when you go to the narrower identifying features, what they are called individual characteristics of the firearm, there, Colonel Mangena says, I have matched the firearm to the scene bullet. Their expert says, I see some matching, but it is not complete. Therefore, I cannot say it's a match. But essentially, what it boils down to is that there is no real dispute of the evidence given by Colonel Mangena. Safe to say, our expert does not see some of the individual characteristics.
Let's move on now to the lawyer for accused number one, again, giving an alternative of what actually happened inside the house. He's put his version to Colonel Mangena to say Longwe Twala is the one that fired the fatal shot, but he says it was a 38 special, a revolver, and not necessarily a 9mm. Now, this is what I find interesting. He's saying it's a 38 special, but the gun that he says may have been used by Longwe Twala is his father's gun, but his father's gun is also a 9mm. Is there a point in putting this assertion to the witness, and how would it help the court?
Linda, the version that was put about what happened in the house is problematic. I think when you watched the proceedings, there comes a point where the judge was asking who is the witness who will come to testify that it is Longwe Twala who fired the gun. And this is because it stems from the fact that in the house, we know the individuals who were in the house. The mother of Kelly Kumalo, Tokozizi Twala, Zandi Kumalo, the deceased, the other gentleman, I forgot his name, the other friend to the deceased. Now, if these were the people that were in the house, these are the only people who possibly could have seen that who is the person who's firing the shot. Now, when that proposition is put to say that Longwe Twala is the person who fired the bullet, but you do not relate that to the people that were in the house, the people who were in a position to see that it is this individual who's firing, it becomes very problematic. That is the first problem I think that the defense is going to encounter in the matter. The second problem that they are going to encounter is that at the scene, there would have been photographs taken of the bullet recovered. Now we know from the two experts that the class characteristics of this bullet is a 9mm. There is nothing that suggests that there was ever a 38 special bullet in any of the pictures that were taken from the scene or in any of the items recovered. Now, that is the other issue that is going to be very problematic with this proposition that a 38 special revolver was used.
And what is interesting about what Mangena is saying about the consistency that he finds with the 9mm bullet is that even the bullet damage in the house was a 9mm. And the defense's expert would not have that particular information or would have had the opportunity to examine those bullet damages because, I mean, it's almost 10 years later. And the house, as we know it, is now under the ownership of other people. And, you know, the Kumalos no longer live there. Do you think there's a point there that can also be made by the state?
The problem, Linda, is that from all the available evidence, there is nothing that shows physically, from the physical evidence, there is nothing that shows that there was a 38 revolver on the scene or that it was used. There is that evidence from some of the witnesses, apparently from their statements, that suggest that they say they saw a 38 special. But one would then have to be mindful of the fact that members of the public might not be very familiar with identification of firearms, and that an error that cropped in might be the reason why some of the witnesses have been talking about a 38 special. But what is decisive is the physical evidence on the scene, and the physical evidence on the scene seems to only point out that there was a 9mm pistol that was fired in the house.
You know, some people would argue that this evidence is quite crucial and that this case may stand or fall on the firearm. And if the state is able to prove that this indeed was the firearm and this is the person that fired the shot in the form of accused number 3, what impact will it have on accused number 4 and 5 who have grouped themselves with him, saying that day, particularly that evening, I know with accused number 5, he even went as far as saying, we lived together. They were together. Would it mean that then, because they say they were together, then it would mean that possibly they may have been at the Kumalo home?
Look, the evaluation of evidence at the end of a trial is not done in separate silos or in separate boxes, so to say. The evidence must be taken as a whole. Now, the fact of connecting the firearm to the scene is very important for the state, because if the state manages to show that this is the murder weapon, and the murder weapon was found in the hands of one of the accused persons, that itself forms a crucial link between the commission of the offense and that accused. But there are other pieces of evidence that must be taken holistically together with this evidence pertaining to the firearm. And when one looks at the totality of the evidence, including the confessions, including the cell phone records, including the other identification that was made by other witnesses. There's a witness who says he was with the accused at a hostel. All this totality of the evidence will be looked at together as a whole. And from that, the court will determine as to whether the linkage between the accused and the offense or the crime that was committed, whether it has been established or not.
All right, thank you very much. Always a pleasure to have you on the program. Kabelo Siabi, who is a legal analyst, helping us understand this part of evidence of ballistics experts. Mangena, as you may know, it is back on the stand on Monday for further cross-examination. You and I will catch up again next week, Sunday, on the upcoming week's evidence. Until then, take care.